Okay, this might work. Hopefully I'm not embarrassing myself in front of a bunch of people. Let's see here. Hey, what's up? Shakisha? Yeah, I spent like all night writing and trying to figure this thing out. And I kind of forgot about the actual stream part, so hopefully I have enough coherent stuff together. Hey, Oasis. There are like UCAT and Cat, not Williams Cat. It always throws me off. So, well, I want to give a few minutes before I start. Anybody have any um, questions or requests for content or things to go over? Because I was going to just go over the YFN indictment because, hey, Ashley, because I thought it was kind of funny how wrong it is and how predictably wrong it is, too. It's not even wrong in like an original way. But if anyone wants to do anything else, you can definitely do that as well. Hey, Mish. I think I recognize everybody's name from Twitter or wherever else. Thank you everybody for coming now. Yeah. That's right, Trikisha. Um, I guess I could just go ahead and get started on the. I actually don't know what it stands for, but I could just scroll down through this and find out. I'm pretty sure it's something I'm not going to say. But yeah, so this is a RICO case in Fulton County, or Atlanta, basically, Georgia, and it was brought by the same district attorney as the YSL RICO case, and there are some similarities between the two. A lot of the counts are the same, and the YFN indictment was brought first, not by a lot, but it was about a year earlier, and I hadn't looked at it until recently, but I had just by looking at some of the counts, I could guess what some of the problems with it were, which is kind of a sad state of affairs. Yeah, that's right, Lucci. He is. Where is he? There he is. This guy. He was Lucci. He's a rapper. He still is a rapper. He is kind of, I don't know, in the canon that the gang investigators have come up with, the rival to Young Thug and Yak Gotti. And if you watch the YSL trials, somebody stood on his car, and that was a whole thing. Um, this guy is, I think, also a rapper. And this guy, Malik Stanley, is the one that caught my attention because of the charges that he had. He is, hold on, let me make sure I have this right. So he's counts 1 in 32 to 67. One is the RICO. Actually, let's go through the RICO first because that will tell you and me what the case is about. You can see there are a lot of accounts here. A lot of counts here. 107. It was 105 in the last version, but some of them got pled out, I guess. Okay, so this is count 1. This is the RICO conspiracy. It's the same as in the YSL. Mostly the same language. I think a few words here or there are different, but I'll just read through this first. This is the first time I've covered this. with the offense of conspiracy to violate the RICO Act, the said accused persons, together with unindicted co-conspirators in the county of Fulton and state of Georgia between the 28th day of May 2010 and the 6th day of July 2023, did unlawfully conspire and endeavor to acquire and maintain directly and indirectly an interest in and control of money and property through a pattern of racketeering activity. So actually, let me just highlight this real quick because we're going to cover this at some point. It's probably the first thing we go over. Pattern of racketeering activity in violation of 1614.4a. That's basically one of the two ways you can be one of three ways that you can be liable for RICO, A, B, and C. So that's A, is basically trying to get, you're conspiring to get money or stuff, property, cars, whatever. Okay. The second part, while associated with the enterprise, did unlawfully conspire and endeavor to conduct and participate in, directly and indirectly, in enterprise through a pattern of racketeering activity in violation of the, what does it stand for? Something Code Georgia annotated. Original? Hey, Cat. Man, Cat knows more than I do. This is going to be embarrassing. So the B is you participate in an enterprise through a pattern of racketeering activity, which we're not going to talk about because it's super complicated. And then the actual charge here is 1614.4c. That's conspiracy to violate RICO. Yeah, and this language down here at the end is just in every count you'll see in Georgia, incorporated by contrary to laws of said state, good order, peace, and dignity thereof. So this is super long, and it's just going to give a full description of everything that they ever probably didn't do. But yeah, this is what YFN stands for. Not going to say it. Each defendant was associated with one or more blood sets in Atlanta, Georgia, and Miami, Florida. See, okay, here's the thing. If you're not familiar with Atlanta, you can't just be in one gang. You have to be in at least two gangs because they're hybrid gangs. So if you're a blood, you also have to be a Crip. If you're a gangster disciple, you also have to be a blood. It's very complicated. At least that's what the detectives tell us. Anyway, so this is background. They're going to give a rundown of different gangs in Atlanta. They change what they say about these gangs every other day. So it's going to change depending on what indictment you look at. Bird Gang, which I'm still not convinced is real. There's ABG, it's another blood set. And I'm going to share all this stuff on Twitter after this, so if you want to look through this stuff, you can. But basically all you need to know is that this is all going to be... Oh, Sarah. Okay, Sarah. What is RICO? Basically, it is organized crime. So say you have 10 people together. I'm glad you made it here. So RICO, it's a conspiracy. It's a criminal conspiracy, and it lets you charge everybody in the conspiracy as if they had done everything. So say that I rent a car, and Kat, not Williams, drives the car, and Sarah D. Let me see. She does a drive-by with Kat. So all three of us could be charged with everything. Even though I only rented the car, which isn't a crime, through RICO, I could be charged with the drive-by. And also, the government can seize all of the stuff. They can seize the car that I bought. They can seize my house if we planned the drive-by in the house. Basically, it's just a tool that is used I don't know what green names mean. Um, but yeah, basically it's a tool used to um, assign criminal or civil liability to a large group of people that are all conspiring together. Yes, that is also correct, Ashley. Um, okay, I'm sorry, I just saw this sentence. This association initially involved bloodhounds allowing YFN to film videos and have presence in a notoriously inaccessible part of Miami. Oh, that'd be cool. Associates will use traditional blood identifiers in structure, as well as share rivals. Mean people buying or being given memberships. That sounds nice. Snacks for everyone. Oh, right, I did actual work to prepare for this one. So the first part is that I want to talk about is, oh, what was I going to talk about? These are ex post facto laws. See, this first act is in 2010, and the law changed from 2010 to now when they wrote this. And I got this list here. Let's see if you see this. This is a list of every different version of the relevant law. You don't need to know exactly what this law is, but I pulled this up and you'll see that you have different versions. This one's changed a lot. This is basically outlining what sorts of things are crimes and what sorts of things aren't crimes. What things can get you in trouble under RICO. And as you can see, it changes a lot. And as we know in the Constitution, there's ex post facto protection, which just means that you can't be charged with something. Ooh, just heard from somebody interesting. You can't be charged with you can't be held responsible for violating a law that didn't exist at the time you did the thing. So if I rob a store, but robbery wasn't illegal at the time, you can't pass a law that makes it illegal and then charge me with robbery after the fact. It's basically an after the fact rule. So I was looking at this and I saw that it dated back to 2010, and I was pretty sure they were going to mess this up because it's what they do. So I pulled the version that was in effect on May 28th, 2010, which is here. And I compared it to this. This is something you should do. Oh man, I was trying to give a hypothetical, Cat, and I started getting too close to something that actually happened. And I was going to be like Garlington was in the driver's seat. It seems like RICO helps the government oversteps people's rights. That is correct. That is, ooh, we should do that next. We should do a stream on civil asset forfeiture and RICO cases because that was relevant recently. And I think there's a hearing soon on that in Georgia. Georgia seized, what was it, 10 pieces of jewelry, a Mercedes, $187,000 in cash, then like some random cars, some other jewelry. But yeah, RICO definitely helps, particularly in Georgia. There are different versions of RICO in different states, but Georgia's is particularly expensive. Where was I? Reginald Carter, aka Lil Blood, which is a very creative name. is Lil Blood, an associate of the Bloods, did unlawfully traffic cocaine, controlled substance. It's a good thing he didn't lawfully traffic cocaine. And did unlawfully possess a firearm, which are overt acts and an act of racketeering activity. So this is the law, and it's in 2010. So this is the version. It says 1614.3, 5A 34. There's no 5A. So it broke. It should be Section 8. Talking about laws. This is a better example because it's actually something I can point to. So this is a law. It says they violated this, 1614.3. I don't know why they number it this way, but 5A and then 34. But when you go to the law that's in effect at the time, there is no Section 5A at all. There is always a little. There is. So this is something that came up in the YSL trial too. And really any case that you have dating back this far, you can usually, I think you can get this even just on Google, get different versions of the law and check, because a lot of times it's going to be messed up. And who do we have next? This is the next version. Oh, wait, I don't have anything for this one, though. Let me see. Okay, so the next version I have is basically the same thing, 1614.3. That corresponds to this version. Still no, where did I put it? We still don't have a 5A at all. So that's also wrong. I'll show you. This is the code section up here. And then this is where there should be A, but it's not there. $5 years for a predicate act. The 5 years is the minimum for a for the RICO sentencing. So if you're liable under the RICO, you get at least 5 years. I didn't even know I had an algorithm yet. And let me just show, these are also, all of these are wrong because they all have 5A. There's no 5A yet. And this in 2015, I think, is the more recent one. Let's see if it's here. Yes, so this is when they switched it to 5. So we can show racketeering. I have so many cases that I try to research. I'm not even looking for cases. I start researching stuff, and then I find more cases on accident. Recently, people started asking me to actually work, like contacting me, which I've never had before because I've always worked at law firms until like a month ago. But yeah, so see here, overt acts and active racketeering activity. This one, not this one, this one. We finally have racketeering activity. So the first, I think, 5 years or so are just completely out for this indictment. This is the first one that's correct here. And that's September 15. And you have to go back, it starts in 2010. So all of those are, I guess I'm technically a defense attorney, Sarah. I was a bankruptcy lawyer, and then I got mad on the internet in Cat's chat, and I talked a lot, and eventually I ended up representing somebody in Fulton County. where I'm not actually licensed to practice. So I had to leave my job. And I guess I'm a defense attorney now. I only have one client though, so I'd be great at some combination of consulting for strategy. I just want to hit all like the rap trials, Florida is right next to Georgia, so just swing down, take care of Melly, come back to California, do the Lil Durk trial. Not touching the Jay-Z stuff. I don't want to get that Busby juju on me. Anyway, so that is the first thing from YFN. You have to have laws that exist to charge people. And this is one case that says what I just said, but better. It is a Court of Appeals case in Georgia. They're talking about RICO. Down in the footnotes, it's a super boring case. It's about check cashing fraud schemes, but you'll see that in the footnotes they go through and list all the years that they're looking at. What the Moontook origin story? Yeah, that's a good one. I forgot about Baby. That's the one I was thinking of. That Baby indictment is going to be coming soon. Yeah, Sarah, I like doing everything. I like learning new stuff. Melly's case is interesting. I think it's like 2,200 days, 2,100 days now that he's been locked up. It is a ridiculously long amount of time. And I don't think the state understands how close they are to getting their case dismissed. And they probably should, to be perfectly honest. The fact that they had all that stuff during the first trial is ridiculous. Usually getting a new trial is the way you address, sort of prejudicial errors or having your constitutional rights infringed upon. But it seems like the first trial was already questionable. The first trial was the infringement upon the rights. So, up to me, I'd like to see the thing dismissed right away. And now, I bet Kat knows where I'm going with this, because there's one set of laws. Actually, let me show. Here we are. This is why I knew they were going to mess this one up. They don't know how these laws work. Nope, that was not what I meant. I don't know. Line, I guess? 131, 133, and 106. And then it's down here again somewhere, I think. Yeah, same set of 3 laws here. I think there's one more. Yeah, these 3 here. So they charged the same set of 3 crimes 3 times. That rhymed. And let me see. This set of 3, not so much 106, but they get this wrong every single time. First of all, they call these 2 things the same name, but they're different crimes. See, and the way you know that is because there are different numbers here. And in my other window, let me just pull it up here. This one is something I've worked on a lot in the past with my client. And I think Shannon Stillwell and YSL also had these. Quay Marvis Nichols had these 131 and 133. Who else? There are a few others. But I guess I'll start with Sorry, an OBS thing. Does this work? Let me see. Nope. Okay. Gonna put myself up here. Okay. All right. Hold on. Does this look more or less okay? I can do a full Moontick stream soon. I just need to some stuff needs to happen first. Drew, find the I've heard that name recently, actually. I'd seen the name before, but I saw his name recently. I can't remember where. I think Steve Sada was talking about him. Yeah, some of my Twitter rants did disappear when they became trial strategy. He is doing good. He's much more patient than I am. We want to get him out as soon as possible. Ideally, within a month or so. I want to get him out like tomorrow, but that's probably not going to happen. Thank you, Kat. Yeah, my video is not coming through very well on YouTube, but see, yeah, quitting your job is the way to go. It's definitely the best thing you can do. That is, I will. He knows. He's kind of surprised and amused by the fact that people suddenly know who he is. I hope. I mean, I mean, I know he's grateful, but he's nice about everything now. He's more patient than I am. But we're gonna have news this week. I was hoping to have it this week, this past week, but there'll be something this week for sure. Hopefully Monday. I certainly expect Monday. I'm sharing. Okay, good, Sarah. Yeah, I'm sharing some of the stuff that we've done with some other lawyers in Atlanta, but I think that we're in very good shape. I'm very confident. I'm impatient, but I'm confident, and I'm really looking forward to telling everybody. His story is really the most important thing to me. Obviously, getting him out is the most important thing, but I think the perception of who he is and his level of intelligence and his character are misunderstood and underestimated, even among people who support him. He was. A lot of people feel bad for him and feel like he was taken advantage of and that he wasn't smart enough to understand what was going on. And we'll see. I'll explain some of that stuff, but I don't think that's the case at all. I think quite frequently he was right and everybody else was wrong. Sometimes for very long periods of time. So my approach isn't so much begging for forgiveness as it is explaining why he's right and everybody else is wrong. Also, he's like too nice to say that, which is frustrating, but I'll say it for him. I'm trying to think if there's anything else I should say. But let me see. But yeah, he is doing very well. Yeah, I mean, certainly I think that's, I mean, got us. Yeah, I agree, Ashley. That's this is the one thing that I refuse to keep secret is the at his probation revocation hearing, there was a reading of his prior convictions, and several of them are wrong. But the most egregious one was they said that he'd previously been convicted of I mean, it was kind of mumbled, but it was either aggravated sexual battery or attempted aggravated sexual battery, and that's just completely wrong. Um, it's not even close to true. And it is funny because I've talked about half this stuff on Twitter before I knew that I was going to be representing him. But quite a few of those convictions were just wrong. And I would like to know how that happens, but I don't know if we ever will. And I definitely don't think he got a fair break. I think that a lot of people let him down. Um, and like I said, I don't think it's a situation where he was taken advantage of because he didn't understand what was going on. I think. Oh yeah, Cat. No, it definitely was. I meant the part whether it was attempted or the actual. I know I have a pro hoc that I have to protect. Um, I have I have some stuff to say after the case is over, but I don't want to get my admission revoked. Usually, I'm the messy one. This is I don't know if I like this role reversal. Um, yeah, Cat. It's mm, I'm excited. I'm excited for her day in court, and there are a lot of people. There's a lot of blame to go around. Yeah, I mean, I definitely will. I don't want to say anything for him that I don't want to speak for him on things that are his to share, his to say. But definitely, it would be fun to have him. It'd be fun to have him on a stream and let him say his piece. And as unfair as things appear, there I promise there are worse. And he's kept in good spirits, and he's always happy. He has a very you know it's out of my hands, so I'll relax and whatever will be kind of attitude. But yes, very soon there will be news very soon. Hopefully in the next few days. And Kat, actually, I think I said you were the drive-by driver, not just so much the getaway driver. Oh man, I don't even know if I should go back to the this 131 stuff. It feels like a kind of a letdown now if I start talking about statutes again. Yeah, it really is. He needs to write like a book or something. He's like a monk. He's just. I mean, I'm not going to get into like the prison situation, but it's not great. Um, it's quite not great actually. But yeah, he's incredibly mentally tough. Okay, okay, I'll go back. I'll go back to statute. Some of this stuff touches on mooting stuff too, but Yeah, Kat, you're like Quindarius Zachary. You can drive and shoot AKs with both hands at the same time. Saw that charge on his record. Yeah, Mitch, that's right. Yeah, I can't. I've tried to read whole motions, but I feel like nobody wants to listen to me read all that stuff. But then I listen to people read whole motions too. But okay, I guess I'll do this part. Wait, what's the other part I was going to do? We could talk about the YSL, the third YSL thing I was going to cover, and then we can come back to this maybe. Hey. Okay, I'll do the 131 thing. I'm not reading this one though. This is ridiculous. So I said I was going to give. When am I moving to Georgia? Well, I went to Georgia, and I went to Georgia for a meeting actually, and it's funny because I'm in Los Angeles, and I flew to Atlanta, which isn't super close, and I got there, and then nobody showed up to the meeting. So that was awesome. That was a great time. Yeah, that was cool. Anyway, 131. Any person who is on probation. Oh my goodness. Oh man, I was so mad. Who's on probation was sentenced for a felony. Right, okay, I remember what I was going to say. This is the part about reading statutes or analyzing statutes that makes it easier. Don't read them all in once. Copy them into Word and chop them up, and it makes it a lot easier. So this is 131, which is possession of a gun by a convicted felon. Well, yeah, I did a podcast with my co-counsel, Tiffany Adams, who is amazing. But I could have done that by the internet. But okay, so this is what I do when I'm reading a statute. I put it into Word. I actually did it with this one and the next one I'm going to show. So this is the code section. It's possession of a gun by a convicted felon. So I just kind of break it into sections. Any person who's on probation, who's on probation with sentenced for a felony under 1613.2, you don't need to know what that is, or who has been convicted of a felony by various courts. And okay, so this is the first break. So any person, can you see this? Yeah, you can. Who's on probation, then you want to highlight where it's like or. I guess there are a few ors, doesn't matter. So these are all the different ways. Yeah, she is. I was trying to get her to say more, but she was good. But so these are the people who are going to be eligible to, I don't know how you want to say it, but be eligible to be liable under this section. You have to be, actually this is going to be one section. Okay. Let me do it this way. I mean, I don't really know if anyone was going to want to listen to me talk about statutory construction for however long this is going to be. So I'm glad people are giving me something to talk about. Okay, all right, so we're getting there. So this is kind of the first part, is the any person part. So we know who that is. And this is the next part, who receives, possesses, or transports a firearm commits a felony. Okay, so pick that up. Upon conviction thereof, shall be imprisoned for, I know this part's important. I'm glad that I edited that fast. That's pretty much all I do is word stuff. Upon conviction thereof, there are 3 different ways you can get sentenced. This back actually. I'm doing this really badly. So this one's kind of tricky. Okay. Can read soundtrack. And is there something I can't hear? I have my headphones in. I can close my window if we need to. So this is a funny statute because I'm pretty sure they drafted it wrong. Yeah, that's right, C. Johnson. Yeah. Anyway, so somebody who basically has been convicted of a felony, this is what it is 99% of the time, who receives, possesses, or transports a firearm. It's usually just possesses. And then the 3 sentences are kind of the, I see. Well, there's Los Angeles, so. Let me see. Upon conviction thereof, shall be imprisoned for not less than 1 year, nor more than 10 years. Then provided, however, means subject to the next part. The next part is, upon a second or subsequent conviction, such person shall be imprisoned for not less than 5, nor more than 10 years. Then provided further, so it's like another qualification, if the felony for which the person is on probation or has been previously convicted is a forcible felony, then upon conviction of receiving, possessing, or transporting is superior to 5 years. Now, this is interesting because in theory, it should be 1 to 5 years for this part, or 1 to 10 years for this part. Call this first one. So this one is 5 to 10. This one is 1 to 10. But then if it's a forcible felony, it's exactly 5 years. And then this part that says 5 to 10 is subject to the exactly 5 year sentence for forcible felonies. So in theory, it's to say you have your 3rd conviction, so it should be 5 to 10 years. But it was a forcible felony. That means it has to be the minimum. It has to be exactly 5 years. I can like type this up or something. First conviction. Oh man. 10 all this pressure to type correctly. But yes, and I can prove that it's this way too, because I have, let me just try the right one. Yes. Show my PDF again. This is the law that was passed that amended 131. It's been amended once or twice since, but they're not really important. Not major changes. So this is sort of what the red line text looks like in Westlaw. I don't think it's probably prepared by like the legislative aides or something. But you'll see here, affect Young Thug's plea. No, I don't think so. I don't think much is going to affect Young Thug's plea, actually. The one person whose plea could be affected that I can think of is Shannon's. Last night, I was positive that Shannon's conviction should have been 5 years. Let me pull up his... Where is it? Where did I put it? Hold on. Ah! I'm in the void again. Let me pull up Shannon's. Hey man, I get it to show on Christian Eppinger in the YSL case. I found so many of his filings recently, and they're wild. He was hooking up with a courtroom deputy. His lawyer went to jail. What else happened? He fought some other deputies. It's just weird stuff happens around him all the time. Where did I put it? Oh, here it is. Okay, sorry, I found it. This is this is Shannon's sentence. This one here. As you'll see, this is what we were just talking about, the 131, 133 thing. I think this should have been a 5-year sentence. I think this was probably a mistake. I shouldn't say that. There's a 50-50 chance it's a mistake. Because his prior, this is what we were just talking about actually, some of his prior felonies were, man, I realized I said this whole thing wrong. I just described everything wrong for the past 10 minutes. It's probably too late to make it up now. He should have had I think he should have had the 5-year sentence on this count. I realize I said everything wrong. Okay. Let's go back here for a second. I need to fix what I said. Let me see. So it says, if the felony for which the person is on probation or has been previously convicted is a forcible felony. Let's put this down here. So it's an if-then statement, basically. So it's if your prior felony conviction was forcible equals 5 years, not if this one's 5 years. That probably doesn't make sense. So if you look at Shannon's, some of Shannon's prior convictions, they are forcible felonies. Okay, I will. I'm not going to go into his priors because he got acquitted of a bunch of stuff and I don't want to, but some of his priors were forcible felonies, and to me that means it should be the 5-year sentence for Shannon, not for the not the 10-year sentence that he got, not that he received. There's several other problems with his sentence, but we can come back to that in a second. Let's see. Okay, so this is the next gun or firearm, common firearm count that you see. This is just if you have a gun while committing a felony. And one interesting thing is this right here. Can't be worse. Yeah, I've done that. Where should I put this? This is different from possession. So this is on or within arm's reach, whereas the 131 is about possession. So those are different standards. A lot of times they're treated the same. There's no practical difference, but sometimes there is. So here we go. Any person who shall have on or within arm's reach of his person a firearm or knife during Christian felony, and they can't just be any. It's 106. Yeah, it is. It needs to be any of these specific enumerated felonies during which you have the gun. So any person who shall have a gun during the commission of any crime against or involving the person of another, that means you're shooting at somebody or punching somebody. Unlawful entry, you know what that means. Theft from a building or theft of a vehicle. Selling drugs, selling other drugs. And which crime is a felony. I mean, it's better than, not thinking you're talking or not thinking or thinking you are muted and then just saying a bunch of wild stuff. Probably. Okay. So yeah, if you have a gun, you do these felonies, you do one of these crimes and it is felony, you're violating the statute. And you shall be punished by confinement for a period of 5 years. And this is important. Such sentence to run consecutively to any other sentence. And usually the default is kind of concurrent sentences, so you serve everything at the same time. Yeah, for sure, Sarah. Although Georgia doesn't have a gun registry, the way most things do. If you have probation, then yeah, you're definitely subject for revocation. Priors, that doesn't come into 106 as much. I'm going to be a pro with so many members. That sounds like a lot of pressure. I think this is probably the sweet spot here. But 106 is relatively simple. If you have a gun and you do a felony, you're going to do 5 years after all of your other sentences. And this concept is really important in 133, which is the most severe. It kind of combines the other two. and it is, oh man, I'm getting so mad at Fulton County right now. It's if you've previously been convicted of a felony and you have a gun during a new felony. It's sometimes called something like possession of a firearm during a felony by a gun felon or something like that. There's no easy way to put it, but we'll do the same thing with this one. Previously been convicted of, oops. The offense of, I'm not going to break all these out, but any of these felonies that. So any person who's previously been convicted of or pled guilty to any of these crimes, these are all serious crimes, or any felony involving use or possession of a firearm. And again, this isn't possession, this is have on or within arm's reach a firearm during the commission or the attempt to commit. I think these are mostly, if not exactly the same as the prior. Yeah, exactly the same, I think. But in this case, it is a much more serious penalty. You get 15 years. Isn't that all of Georgia? Yeah, it feels that way. Upon conviction thereof, shall be punished by confinement for a period of 15 years. Such sentence to run consecutively. So if you get this, you are getting sentenced to exactly 15 years. And it's going to be 15 years after every other sentence imposed. So if you have, let me see, go back to our first. Hold on, let me see if I can find it here. I had everything in one little folder, and I got off track. Here we go. Showing everything right? Yeah. So this one, yeah, this is an example. This is wrong, by the way. This whole box is wrong. But so you see, this is consecutive to count 37. Everything, this is also consecutive because it's 106. But for the most part, everything's concurrent. So if you start getting these 106 and 133 charges, it adds up your sentence really, really quickly. 106. So this is consecutive. I think there's one more at the bottom somewhere. Yeah, this one's also consecutive. And so for the most part, the judge wanted to give concurrent sentences, but they don't have a choice for 133 or 106. It has to be consecutive to all other sentences. So if you have a bunch of 106 or 133s, they stack up one after another, and judges have no discretion on that. Now, the funny thing, this is where they messed up. This is one of the places they messed up. Let me pull this case real quick. this case. Yes. So this is one of the things I want to talk about today. This is a concept called, let me zoom this in a little bit. Okay. Let me check, see if this works. Yeah, I didn't know how to go live like from a scheduled stream, so I just kind of had to wing it. But merger is the idea that you have, let me see, let's say you have a murder case. Underneath that, you could have manslaughter and attempted murder and aggravated battery. Under that, you could have assault. You could have, let me see, various firearm charges. You could have weapons charges, and all of those, out of that one conviction, you could charge somebody with 50 or hundreds probably of lesser included offenses. And one example, we actually just looked at it, is here, is 131's included within 133 because it's less severe and you need to prove less stuff. There are less elements. So you don't get to have both. You have to pick one, and usually you pick the more serious one. But if you can't prove the more serious one, sometimes you can get the less, it's called the lesser included offense. What's this term here? And there's another one, Stanley, I think I saw. Yeah. So here, you charged with armed robbery, but they apparently couldn't prove it, and so they got him on just regular robbery. So they probably couldn't prove that he had a gun. But you can't charge somebody with robbery and armed robbery because you're just going to end up with countless offenses at that point. And so what you say is, say they had charged him with robbery and armed robbery, and he was convicted of both. You say the robbery count merged into the armed robbery count. Let's see if I can think of an example of that. We had a merger issue. I don't know if I have any offhand. Yeah. Yeah, I can't think of any cases that are recent that had merger in the sentence itself. But yeah, the idea is that they're basically in opposite directions. If you can't prove a severe or the most serious crime, but you prove something lesser, then those are the lesser included offenses. If you prove everything, then the lesser included offenses merge up to the more serious. The more serious crimes, basically, you don't get to have both of those. And I completely forgot where I was going with this. Oh, this case. This talks about 106 and 131, 133 in the context of merger. And the most important thing is that 106 and 131 both merge into 133. So you can't have, if you have 133, you can't have either of these in addition to that. It has to be, what's a better color? Oh my God. You know what? That's going to have to do. So in this case, this guy, Jones, was convicted of It's always Antonio. Why is it always going to be Antonio? Antonio Sumlin, Sledge. Yak received 10 years. Yeah, that was a messy case. That could have been serious as well. Rod and Blaylock's case had a merge charge. Yeah, that's a really common one. Malice and felony murder. Felony murder will merge into malice murder. Yep, that's true. So let me see here. In May 22nd, 2000, that's like right when I graduated high school. Charged by indictment with, if this is what you just said, that would be funny. Malice murder, 2 counts of felony, ag assault, possession of firearm during the commission of a crime, that's 106. Possession by a convicted felon, that's 131. Firearm by convicted felon during the commission of another felony is 133. He, at trial, he admitted the shooting, but claimed he acted in self-defense. The jury returned verdicts of not guilty on all of the murder counts, so no merger on those, and the aggravated assault count, and verdicts of guilty on the 3 firearm offenses. That's curious. How did he get possession during commission of a crime, but then only get convicted on the gun counts? That's strange. Anyway, the jury returned verdicts of not guilty on all the murder counts, the ag assault, guilty on the firearms. The trial court entered judgments of conviction as to the firearm offenses, sentencing Jones to serve 5 years for possession during the commission of a crime, 5 years for possession by a convicted felon, 15 years suspended for use of a firearm by a convicted felon during the commission of another felony. Jones appeals. Inconsistent verdicts. That is what I was wondering. I wasn't going to read this, but I'm curious now. Jones argues that the trial court erred in accepting inconsistent verdicts of guilty as to the 3 firearm offenses and not guilty as to the ag assault and murder charges. Regardless of whether or not the verdicts were inconsistent, there is no prohibition against inconsistent verdicts in Georgia. It's a long excerpt. It says, 1986, the Supreme Court abolished the rule against inconsistent verdicts in criminal cases. Appellate courts cannot know and should not speculate why a jury acquitted on one offense and convicted on another offense. See, you don't need to know why. It just doesn't make sense. The why doesn't matter. There are a lot of whys. They're all dumb. There are no good whys. All right. We're not going to get into that. The case of Turner, cited by Jones as inapposite. In that case, the abolition of the inconsistent verdicts rule did not apply because the jury's verdict form made the basis for its verdict clear, and thus the court did not need to speculate about whether the verdict was the product of lenity or legal error. Lenity just means if you have 2 options, the defendant gets the less severe option. Yeah, Mish, I don't know what the crime was for the gun charge. That doesn't make sense to me. That is odd. Anyway, here Jones made a showing trial court's decision to use a general rather than a special verdict form as an abuse of discretion. A general just lists out the counts. A special will usually inquire as to the elements, and you'll get more information from a special verdict. And given the trial court fully and accurately instructed the jury on the presumption of innocence, the definitions of the crimes, burden of proof, and the defense of justification, and the form of the verdict, we find no error. Okay, here we can skip prior convictions. I stipulate. I remember reading this. Okay, merger. Jones asserts that the trial court erred in failing to merge for purposes of sentencing his convictions both for possession of a firearm during the commission of a felony and possession by a convicted felon. with his conviction for use of a firearm by a convicted felon during the commission of another felony. We agree. When the same conduct establishes the commission of more than one crime, the accused may be prosecuted for each crime. So that's an important distinction. He can be prosecuted for each, but not sentenced for each. But he may not be convicted of more than one crime if one crime is included in the other. To determine if one crime is included in another, we apply the required evidence test adopted in Drinkard versus Walker, 2006. As explained in Drinkard, the applicable rule is that where the same act or transaction constitutes a violation of two distinct statutory provisions, the test to be applied to determine whether there are two offenses or only one is whether each provision requires proof of effect, which the other does not. If so, then there are two offenses and neither is included in the other. In this case, the same act by Jones, his use of a gun to shoot Simmons was used, but he was acquitted of that. Okay. In this case, the same act by Jones, his use of a gun to shoot Simmons was used to establish violations of 106, 131, and 133. The count of the indictment charging Jones with the use of a firearm in violation of 133 required proof that he had previously been convicted of aggravated assault and that he subsequently used a firearm during the commission of various crimes against Simmons. Thus, that count required proof of the fact that Jones had a prior felony conviction, a fact that was not required by the count charging that Jones had possessed a firearm during the commission of a felony in violation of 106. But this latter count charging a violation of 106 does not require proof of a fact not required by the count alleging a violation of 133. They're saying this in the most complicated way possible. Basically, 106 fits entirely into 133. There's no part of 106 that 133 doesn't cover. If 106 had an element like your name is John, and 133 didn't have that, then it wouldn't merge. It would be a distinct charge. Steele asked for it twice during trial. Yeah, I think it's at least twice, right? So no, I think he asked twice during the Glanville mess, at least. But yeah, that's their whole move. Second, if you plead guilty, you can walk out the door, but if you want to contest your innocence, they make you stay. Let me see here. And I'm going to repeat the same exercise for 131. Likewise, the count alleging a violation of 133 required proof of the fact that Jones had used a firearm during the commission of crimes against Simmons, not required by the count charging that he was a convicted felon who possessed a firearm. But the alleged violation of 131 did not require proof of fact, not required by the alleged violation of 133. Therefore, the violation of 131 also should have merged with the violation of 133. Accordingly, the sentences for all three offenses are hereby vacated, and the cases remanded to the trial court for resentencing. That is a strange way to do it, because 133 has a fixed sentence. There's no resentencing you need to do. You can just merge 106 and 131. But that is the idea. What this case is. So if you see, where is Stanley? Here we go. So you see up here, they didn't merge. Yeah, I don't know, Trakisha. It's a good question. I think a lot of times it doesn't matter in terms of total sentence, but oftentimes it does. And certainly, like for instance here, the consecutive sentence is suspended. Both of them are. So they're not going to be serving that unless something goes wrong. But it should be caught. The other day, in my country, if you're convicted in district court and you appeal, it goes to high court. They'll also determine guilt or innocent, plus if penalty is correct. That's interesting. I know in Georgia, they used to they wouldn't determine guilt or innocence, but they'd check to make sure that your sentence was right and that there was enough evidence to support your conviction. But they wouldn't do determination of guilt or innocence. But that's interesting. Yeah, as you can see, actually, I'll show the indictment so you know I'm not making this up. Counts 51. You don't need to see how crazy I am. Actually, no, we can keep this. 51 is, so you see 131, 133, 106. You see it's all on the same date. It's on the 15th of September, 2020 for all three. It's the same event. These aren't different events. And let's see, they should have merged, but they did not. So in theory, I think this one should come out, and this one should come out, or they can do it as, you can just cross out this one, and then these two can survive together, which is what they did down here. Yeah, they struck this one here, which lets the 65 and 67 survive. So yeah, that sentence is wrong. Background cleaning music. If the charging documents are incorrect, how are they using the conviction in RICO trials? Yeah, I don't know. I mean, this was the result of the RICO trial. He was convicted on the RICO count, I think, or pled guilty. I can't remember whether it was it was a non-negotiated guilty plea. So yeah, it was mostly right. They got it right 2 out of 3 times, but they just missed the 3rd time, which isn't great, but still. But yeah, that is incorrect. And the funny thing is that I guessed at this one, looking at the indictment. They always get one. Oh, I know what I want to show you. Make sure I don't share too much on this one, though. They have been getting this wrong for over a decade. Close some of these. This is 2009. They use the same title to describe both of these offenses, although they're completely different. And this one actually went on appeal. This was argued by Judge Whitaker. She didn't make the mistake. She's the one who fixed it. Where is... Yeah. Let me see. So this is just the excerpt of the state's appellate brief. Whoa, I missed a bunch of chats. Late to the live. Glad you're here, Chelsea. When do I sleep? I didn't sleep a lot last night, because I was writing until really late. And then I decided to do this thing. Jury trials is mostly 4+ years. Jury consists of X number of judges, X number of late. That's interesting. Thanks for being here, Mary. I am having a great weekend. I do my best work late at night. I stress out partners doing that, but I think other courts is negligence. Fulton County. I understand mistakes happen, but Fulton County is beyond the things they do wrong. 133 seems purposeful. I think a lot of it's training for the prosecutors. You can kind of see them picking up habits. Even during the YSL trial, you could see them sort of picking up mannerisms and habits from the more senior attorneys. There's a lot of turnover, and I think a lot of their best lawyers leave. Like there's a prosecutor named Lisa Dunikowski, and some people think she's the best prosecutor in the state, and she left to, I think, Cobb County or DeKalb County. You have Paige, who was I think she was the chief appellate attorney, and she's a judge now. And I think is it Love? I think Love is supposed to be the person who's doing the training. She's the chief. I think she's the chief deputy. And irrespective of what you think, how you think she did during the trial, yeah. I mean, she clearly wasn't training people for those several years that she was working on that trial. DA in Fulton County wants Thug to pay for their security. Yeah, that was ridiculous. That whole motion was ridiculous. Legally, factually, it was ridiculous in every way. Get through this real quick. Count 8, alleged appellant violated 133 by possessing a firearm during the commission of a felony against and involving the person of another while having been convicted of armed robbery, felony involving use of a firearm. In its exception 47, appellant asserts the trial court permitted the jury to convict him of count 8 without finding that the prior conviction involved the use of a firearm as alleged. The state submits appellant's assertion fails on all prongs of plain error review. Although the trial court's instruction did not use the exact phrase involving the use of a firearm, the court's instruction appropriately tracked the pertinent language from 133 and referred to the offense of armed robbery or any felony involving the use of possession of a firearm or possession of a firearm. Appellant's conviction in case Z98022. Armed robbery with a firearm was that predicate felony. I don't know if I agree with that argument, but further, as the pertinent element from 133 requires a prior conviction for armed robbery or any felony involving the use or possession of a firearm, that's not good enough. The inclusion of both phrases was not necessary. The trial court did not plainly err. So any felony involving the use or possession of a firearm. You can do armed robbery without a firearm, though. I know how this case ended up, and it didn't matter. They didn't have to decide this issue. But that is from, which one was this? Atkinson. This was a 2009 indictment. So this was, 16, coming up on 16 years this year. And you'll see that they use the same name, even though they're different crimes. I haven't read this before. This is a very specific way to write in caps lock. Let's see, 133 here. And 131 up here. And what else do we have? I believe this is the same thing. Yeah, they repeat the same thing here. I think this one was... No, it's a different case. You see what? It's same set. You have 106, 131, and 133. Again, they use the same name, so it's super confusing. And I think this one was also appealed. Almost positive. This was 2014. It was almost 5 years apart exactly, wasn't it? Yeah, just over 5 years after the last one. January of 16. This is actually a case that relates to YFN. This is a Fulton County case. They're members of a subset of YFN, or not YFN, If Gang, Inglewood Family Bloods, called Haiti Gang. I don't know if they're still around. I know Chelsea. I know. Yeah, all three of these guys are, I believe, still in prison, actually. And yeah, same problem here. 131, 133. I think it was just one defendant on this one, though. Yeah, it's just Dominique Carter, who is related to somebody in the YSL case, and I can't remember who. Oh, some familiar names there. Gaither, Kimberly Underwood, Randolph, Tyrone Dennis. A lot of familiar faces. This one is, I think that's the same idea. Yep, same thing here. This was more recently, 2018. Sprinkle, who is a lawyer on the YSL case, he should not be making this mistake twice. Al Hogan, he was on YSL. And yeah, this is Atkinson. And last thing I'm going to show, I'm going to make sure I don't show too much again. This one drove me crazy. This is from the YSL case. This is the first thing that got me really annoyed about the YSL case. Find a good count here. Let's get this one, 53. Okay. So this is the original version. So this charge is 133. It's a little smaller. And this one is the indictment. It's August 2022. They both charge 133, right? I know, Ashley. So this is the first version, right? So I can make this a little bigger. Ooh, this is way too small. Sorry about that. My bad. There we go. Okay. So this is the original version. Charges 133. This is Quay. This was dismissed, so I don't mind talking about it. But you'll see it uses this description. It says, said accused, County Fulton, on the 14th day of March 2022, after having been convicted of felonies involving the use or possession of a firearm. So that's one thing. Then it lists the felonies. Then it says, did possess or have within arm's reach of his person a firearm. That's another element. Then this is important during the commission of a crime against or involving the person of another. Make this different color. Then it's murder, smell, drinks. As alleged in count 49. So this is the original version. This is May of 2022, May 9th, 2022. And then this is the later version. So, yeah, did possess a firearm. As opposed to did possess or have within arm's reach, which is correct. So this is wrong. Then, after having been convicted of felonies involving the use or possession of a firearm, that's fine. Possession of a firearm. Then there's not any of this stuff down here. Any of the orange stuff. See, it just ends after they list the prior offenses. Here it has this whole section, to wit, the murder of Shamel Drinks, a rival gang member, as alleged in count 49 of the indictment. If you remember 133, you have to have where am I? The most important part is that it's during the commission of a felony. Should have honor with arm's reach. So 133 is about having a gun. You're previously convicted, you have a gun, and you're committing a felony. They got it right in the first version. This is the original version. You have previously convicted, has a gun in arm's reach during the commission of a crime. And then somehow by the later one, by August, it's wrong again. They made it wrong in the later version. And this is part of why Shannon's charge got reduced from 133 to 131, because they didn't charge it correctly, even though they'd gotten it right the first time. So that's not great. I can't believe there are more people here than there were before. I'm glad people like this stuff, though. Any requests for other stuff? I have how many cases we can look at. I can just ramble. I can talk about what cases do I have. I can talk about shopping carts. I'm probably going to save that for later, though. Ooh, I know what I want to share. So this is a case. I probably shouldn't even talk about this. This is a case from 2000 and let me see. It dates back to 2002. It wasn't indicted until 2000. I can't remember what date this is. Seizure and how the DA decides whose items she's going to seize. Yeah, you can do that. Let me see here. Actually, no, I should have. That's the Martinez Arnold stuff. How much have you seen of the Karen Reed case now? I've seen it. I mean, I'd already seen a pretty good chunk of it the first time I watched it. That was probably like 6 months ago, I think. They denied the buffer zone. Oh, yeah, I saw that. I can look at that. I haven't looked at that yet. Where is that? I think I can find it. I still have all my stuff set for like the first trial. Let's see if I can find it. Okay, I think I have a copy. Take a look at this. She didn't seize any items from If Gang. What is the deal with YSL? That's a good question. I mean, when they raided Doug's house on May 9th of 2022, they definitely, I mean, I'm sure they had some idea that they were going to find valuable things in the house, but I'm sure that once they got into the house and saw they found cash and cars and diamonds, they probably decided that they wanted to keep all that stuff. I don't know if there was a similar raid for If Gang, and I don't know if they have a single person that has as much wealth as Young Thug does. How much have I seen of Karen Reed? Yeah, I've seen most of it. I haven't seen all of the. I don't remember all of it. I've seen most of it though. I'm kind of trying to save. I don't know how much I want to go back and rewatch the whole thing. Lucci was caught on camera throwing a body out of the car in a drive-by. That's pretty bad. Yeah, he got a plea deal. I don't think he even served all that long. A couple of years, right? But yeah, I think there's a hearing on the. When is that hearing actually? Let me check that, and then let me check the hearing date for the seizure, and then I'll look at this Karen Reed thing. I meant to check the Martinez Arnold hearing date a minute ago for the property seizure in the YSL asset forfeiture case. So I think the main hearing is May 5th for Young Thug stuff. Yeah, May 5th at 9:30. Then I think it might be the same day for Martinez Arnold. Gotta pay my dollar. Yeah, same day for Martinez Arnold. They have briefing due on Wednesday or Monday. All motions are due on Monday, and then the following Monday, responses are due. And then they have hearings on the May 5th. So that should be interesting. I'm looking forward to that. I know Ashley is going to be unhappy. Most of it was, yeah, a lot of that, Julia, was rental. Yeah, that was, what were they called? I can't remember. Yeah, but a lot of it was, a lot of it was thugs, though. I mean, I think it was only like 10 or 12 pieces that the one jeweler that was a party had. 15 years after 7. Yeah, I thought he got out somewhat recently. So, okay, I guess I'm gonna go through this Karen Judge Babs being over. I haven't looked at that yet. I don't know. It's hard to get information on the Massachusetts cases. The docket's not as accessible as some others. It's not the worst either, but it's just hard to get all the documents that I need, which kind of makes it less exciting or less. It just makes it harder to do deep dives when you can't get the information that that I want. Fulton County, you get most of the stuff you want, and all the federal cases you can get pretty much everything. The puppy's doing good. He's sleeping right over there right now. He's been sleeping this entire time. But yeah, oh my. Okay, what is this? What is this? Look at Nicholas. It was a universal deal. Yeah, that's crazy. Jeffrey Noble, Massachusetts State Police. See, now I'm thinking that's not how you spell Morrissey, but I'm sure it is. Jason Grant, Taggart, Peterson, and Lyons. Oh, give me a second. I'll get a puppy. You need a Boston YouTuber. Is she from Boston? I thought she was. I had no idea she was from Boston. And I do need a Boston YouTuber. So we're going to have my assistant here. Memorandum in order on plaintiff's motion for TRO, April 11th, 2025. On April 1st, 2025, 4 Massachusetts residents filed suit against defendants. I'm not reading through all these. Does it say Twan again? They got it right this time. Okay. Department brought suit against the defendants. Plaintiffs allege that Judge Cannoni issued a buffer zone order imposing unconstitutional prior restraint and infringing on their First Amendment and Raffaello, that's right, Brooklyn, and infringing on their First Amendment and due process rights. Plaintiffs filed a motion for TRO seeking enjoinment of the March 25th order. A hearing was held on April 4th. The parties completed briefing on the 10th. That's pretty fast. Upon consideration of the parties' briefs and supporting evidence, the parties' oral argument, and for the reasons explained below, I deny plaintiff's motion. Do we want to do Rooker-Feldman and Younger abstention? I don't think I can do this to myself. He's saying that the federal courts don't want to interfere in state court matters. The standard for, I've done so many of these. The standard for issuing a TRO, an extraordinary and drastic remedy, is the same as for a preliminary injunction. Plaintiffs must show that weighing the following 4 interests favors granting a TRO. Likelihood of success, possibility of harm, absent an injunction, the balance of hardships between the parties, and the effect of the court's ruling on the public interest. I guess this fourth prong is usually not that important, but I'm guessing it's more important here. Citing to a Fourth Circuit case. So they're going to run through the prongs. Likelihood of success. Beginning with the likelihood of success on the merits, which is considered the most important of the four elements and the sine qua non of the calculus. That's a fancy way to say that. Plaintiffs allege the First Amendment rights were violated by Judge Cannoni's second buffer zone order because it is content-based. No, that's fine. Let me just finish the sentence. Because it is content-based, not narrowly tailored, and constitutes prior restraint. Prior restraints when you restrain speech prior to it happening. Brian Koberger, I haven't yet, but I mean to. I'm planning on it, for sure. I know that there's been some question about the DNA integrity or something like that. I'm definitely interested in getting into it. Oh, I'm just going to drink here. In contrast, defendants argued the buffer zone created by the second order is a content-neutral time, place, and manner regulation, narrowly tailored to serve a significant state interest, and that plaintiff's due process claim is based on the flawed premise that they were not granted an opportunity to be heard. Based on the evidence before me, I find that plaintiffs have not demonstrated a likelihood of success on the merits of their First Amendment due process claims. In relevant part, the second order states, no individual may demonstrate in any manner, including carrying signs or placards within 200 feet of the courthouse complex during trial of this case, unless otherwise ordered by this court. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. The buffer zone shall further be extended to include the area bounded by Bates Court, Bullitt Street, Ames Streets, and Court Street. Individuals are also prohibited from using audio-enhancing devices while protesting. That's funny. I wonder if she hadn't said while protesting. That would have been better. Individuals are prohibited from using audio-enhancing devices within the buffer zone. Yeah, I like Andrea. We've never spoken directly, but we tweet back and forth sometimes. But she seems really smart. The second order is almost identical to Judge Cannoni's April 4th, 2024 order establishing a buffer zone during the first state court trial in Commonwealth v. Reed. The first order. In that case, the Mass Supreme Judicial Court held that the trial judge struck a balance. Hold on, I can get my chat open. Struck a balance between the right to protest or demonstrate and the defendant's right to a fair trial. Speakers v. Commonwealth, I agree with the SJC's reasoning and find that plaintiffs have not demonstrated a likelihood of success on the merits of their First Amendment claim, even despite the extension of the first order. Is that a Star Wars thing? To the area bounded by Bates Court, but I'm not reading that again. The extension. Constitutional standard. This is like two intros to the First Amendment claim. You just said that. Okay, that's fine. Constitutional standard. The First Amendment, applicable to the states through the 14th Amendment, prohibits the enactment of laws abridging the freedom of speech. The Supreme Court, however, has regularly rejected the assertion that people who wish to propagandize, protest, or views have a constitutional right to do so whenever and however and wherever they please. I wonder if they probably should have left the first part of that out. Propagandize, protests, or views. Anyway, in a traditional or designated public forum, content-neutral restrictions on the time, place, and manner of expression must be narrowly tailored to serve some substantial governmental interest and must leave open adequate alternative channels of communication. If the restriction is not content neutral, you probably know this, but it means the regulation can't be based upon the subject matter of the speech. It can be based on time, place, volume, but not the actual ideas being advanced. If the restriction is not content neutral, then it must satisfy strict scrutiny. That is, it must be the least restrictive means of achieving a compelling state interest. And these are just stating this standards overview. This is the strict scrutiny standard. And narrowly tailored governmental interest is another standard. But yeah, they're basically just restating the law. Corey Richens, that's the one. Yeah, I've been seeing that one too. Okay, content neutrality. The parties do not dispute that the speech at issue is protected by the First Amendment, that the location is a traditional or designated public forum. Instead, they dispute whether the second order is content neutral. I think it is. Here, the second order bars all demonstrations within 200 feet of the courthouse and within the extension, regardless of the subject matter of the demonstration. I don't know if that's true. I need to check the order again. It's up here, right? Let's see it one more time. Oh, I thought it was up here. Here we go. Such placards. Yeah, interesting. I think during trial of this case, kind of gets a little close to the line. Yeah, this could have been drafted in a more clean manner. Let's see. Here's second order. Bars all demonstrations within 200 feet of the courthouse and within the extension, regardless of the subject matter of the demonstration. Yeah, so it up here is talked about protesting specifically. It didn't say demonstrating. Suggests dissatisfaction with the proceedings, which is kind of content related, or not viewpoint neutral. Determine whether a violation of the second order has occurred. One need not examine the message conveyed. Yeah, kind of do though, because he said protest. Rather, whether plaintiffs violate the second order depends not on what they say, but simply on where they say it. Significantly, any protest against the defendant and in support of the Commonwealth would be equally subject. Yeah, I don't think you can protest in support of the Commonwealth. That's just support. Any protest against the defendant and in support of the Commonwealth would be equally subject to the restrictions of the buffer zone. Prior restraint. Plaintiffs argue the second order is not content neutral because it specifically prohibits demonstrations. It does not prohibit commercial or other types of speech. Here, quoting Madsen, to accept plaintiff's claim would be to classify virtually every injunction as content or viewpoint-based. Injunction, by its nature, applies only to a particular group and regulates the activities and perhaps the speech of that group. It does so, however, because of the group's past actions in the context of a specific dispute between real parties. Parties seeking the injunction assert a violation of the rights The court hearing the action is charged with fashioning a remedy for a specific deprivation, not with the drafting of a statute addressed to the general public. See, this is also interesting because up here they were saying interest was between the right to protest and between the defendant's right. But the defendant's not a party here. Where was I? Between real parties, but they're not the two parties to this dispute. It's between the protesters and the court. But I suppose you'd say the protesters and the state, but that doesn't work as well. Furthermore, nothing in the record indicates the second order has an incidental effect on some speakers' messages, but not others. I mean, it just started, so even if it did, such effect does not render the second order content-based. Thus, I find plaintiffs are unlikely to succeed on their claim. Second order is content-based. Narrowly tailored to serve a significant interest. Even though the second order is content neutral, it still must be narrowly tailored to serve a significant government interest. For a content neutral time, place, or manner regulation to be narrowly tailored, it must not burden substantially more speech than is necessary to further the government's legitimate interests. As stated previously, the second order encompasses the area established in the first order. Here, the trial judge reinstated the buffer zone in that area for the same reasons as the first trial. For the same reasons that it drives me crazy that they say DOC instead of DKT. For the same reasons that compelled the court to establish a buffer zone for the first trial, it is necessary to establish a buffer zone for the second trial to ensure the defendant's right to a fair trial. I'll come back to that. I agree with the SJC's reasoning that the original buffer zone passes constitutional muster. Buffer zone, ensure a fair trial, significant government interest. By physically clearing the path for jurors. This is not a good reason because you can do that without just a simple time restriction. Intimidation and harassment within 200 feet. The buffer zone also helps protect the jurors, who, as the trial judge noted, must remain fair and unbiased from extraneous influence that might result from, for example, viewing pictures of putative evidence directly in their path. Okay. The buffer zone does not preclude the petitioners or anyone else from engaging in the same forms of protest they have previously done. It simply constrains them from doing so within a limited zone tied to courthouse property. In so doing, it leaves open ample alternative channels for communication of the information, just as long as it doesn't do anything. Additionally, the extension will not burden substantially more speech than is necessary to further the government's legitimate interests, the defendant's right to a fair trial. It's interesting that they're speaking on behalf of the defendant here. A state has a legitimate interest in protecting its judicial system from the pressures which picketing near a courthouse may create. It is of the utmost importance that the administration of justice be absolutely fair and orderly. Judge Canody found that during the first trial, the collective voices of groups of demonstrators gathering outside the buffer zone and vehicles honking their horn, the sirens were so loud. Their horns in response to demonstrators could be clearly heard inside the courthouse, despite the original 200-foot buffer zone. Yeah, I have been following, well, not the trial, but the proceedings as them. I'm really looking forward to the next hearing. I hope to see a dismissal because the state's getting away with everything. Maybe I should do a video on Valley next. I don't really know a ton about it, but I've been meaning to get into it. I've started to read more about it lately. I mean, if they just said that, Kat, I'd be fine with that. I mean, that's at least reasonable. But co-opting the person presumably supported by the protests is an odd move. I feel like a lot of this could have been framed better, could have been written better. An anonymous juror from the first trial detailed how they could hear protesters outside screaming and yelling from the deliberation room during the first trial. Where there are groups protesting in front of the courthouse that can be heard in the courtroom, such actions may be presumed to intend to influence jurors, witnesses, or court officials. See, now it sounds like we're getting back to non-content neutral speech restriction, or justification. Anyway, according to an affidavit by Michael Hardman, the original buffer zone was sufficient to prevent disturbances. Who is this guy? Why is he the expert? From the southern, eastern, and northern sides, however, significant noise and honking originated from the western side of the courthouse. But they're not closing the streets, right? It's just that they can still honk. Honk, honk, Hank. Oh, Kat made the joke before me, again. Thanks, Kat. First you get the, what was it, Nicki Minaj thing before me, and now you get the honk for Hank joke first. God. Such honking was in response to signs and gestures from demonstrators. Okay, now this is just not content neutral. As a result, the trial judge expanded the buffer zone to directly include those specific areas west of the courthouse. In other words, the extension directly advanced the goal of ensuring a fair trial. Maybe. Who is he? Was he in the courtroom? I don't know. Anyway, the second order is in effect during a limited time frame. The course of the criminal trial demonstrates narrow tailoring. Significantly, the plaintiffs may still engage in the same form of protest. You already said that. In some, the extension is limited in scope and time, clearly tailored to ensure the defendant's right to a fair trial. This is almost verbatim what they said in the last section. Such safeguards are necessary and appropriate to ensure the administration of justice at this one particular stage is free from outside control and influence. Oh my God, this is painful. I hate this. Ugh. Not sure. Salt Lake City. Plaintiffs argue, just say it, that the second order was not sufficiently narrowly tailored. For example, plaintiffs argue that any restrictions on demonstration should only be during jury selection. Jurors could be brought through alternate entrances, and where there may be reasonable buffer zones enacted, demonstrators could be asked to turn away from a juror or witness until that person enters the courthouse. Contrary to plaintiffs' assertion, that's not even what they asserted, though. They were giving examples. The second order need not be the least restrictive or least intrusive means of serving the government's interests. I know, I misjudged Judge. I don't even want to read this anymore. I'm just sad about Judge. Especially here where the extension served the legitimate interest. It hasn't even started yet, so it prospectively serves the interest of ensuring a fair trial. We have no idea whether it will or not yet. Thus, because the second order is content neutral and narrowly tailored and leaves open ample alternative channels, plaintiffs have not demonstrated a likelihood of success. If he's outside, how could he know what's inside? And is he standing on the west? Touching people. Yeah, it's clearly not content neutral. At a minimum, due process requires that a party be given adequate notice. I hate this citation. This is, you can find 10 million citations to this, and they go to an uncited or an unpublished Lexis case from 25 years ago. I hate it. And then a Supreme Court case from 70 years ago. Anyway, here plaintiffs argue they were not provided a meaningful opportunity to be heard, but do not point to any facts to support their assertion. Rather, the record indicates that the trial judge heard from the community regarding the Commonwealth's motion for a buffer zone, and that local merchants but they're not, okay. Anyway, made requests specifically pertaining to that motion. Such opportunity to be heard is further affirmed by the second order, which indicates the trial judge recognized the list of concerns sent to the court by the Karen Reed Trial Prepare Together group. So she recognized this one list of concerns. Fantastic. A group of local business owners and organizations that experienced issues with protesters during the first trial. Protesters, not content neutral. Okay. Significantly, there's nothing in the record to indicate the trial judge restricted the plaintiffs from voicing their opinions prior to the issuance of the second order. Wasn't this adequate notice in addition to the opportunity to be heard? Okay. Anyway. Thus, plaintiffs do not show a likelihood of success on their claim that there were no procedures in place to provide those impacted with an opportunity to contest it. Okay, Matthews v. Eldridge is correct. Yeah, there's no mention of notice there, from what I can tell. Plaintiffs also argue, I hate this writing, it's so bland, that the second order is a vague, unconstitutional regulation. I can't with this writing. It is established that a law fails to meet the requirements of the Due Process Clause if it is so vague and standardless that it leaves the public uncertain as to the conduct it prohibits. Here, in relevant part, the second order identifies the action prohibited with specific examples. No individual may demonstrate in any manner, including carrying signs or placards. Okay, this is the problem. This is a non-exclusive example. Okay. Identifies the action prohibited with specific examples. These are two of the types of actions, but this is not any manner. This is just something included in any manner. So that's stupid. The second order clearly identifies the area where protesters are prohibited from demonstrating. Within 200 feet of the courthouse complex. What's the courthouse complex? Including the Norfolk Superior Courthouse building and the parking area behind the Registry of Deeds building, as well as the zone of the extension, the area bounded by, okay, how long it will be in effect during trial of this case. Okay. Thus, is that like from what, opening statements through closing arguments during the day? Yes. Anyway, thus it is clear what the second order, no, this is bad. This is the problem in any manner. Host long to finish reading this duck. I'm sorry, federal judges are very talented and their clerks are too. Speculation about possible vagueness in hypothetical situations not before the court will not support a facial attack on an order when it is surely valid in the vast majority of its intended applications. Okay, this is ridiculous. How did you spend all of this time on one of the prongs? This is trash. Reason stated above, plaintiff states motion for temporary restraining order is denied. Am I stupid? I mean, I know I am, but like, there's more than there's. There's more than one plaintiff, and they're not states. See right here, it's this isn't even spelling. This is just counting. That was exhausting. They literally quoted this above too. Stop. What was denied? I don't know. I don't know. The the prohibition on protesting within 200 feet of the courthouse complex during the trial of Karen Reed by protesters, but also is content neutral. I mean, this is not particularly surprising, but they made it a closer call than they needed to. It's very conclusory. Yeah, that's right. That's what I was looking for. Right when I'm about to leave. This is what I was looking for before. Some of the stuff that nobody in particular took from Young Thug. Money, cars. Yeah, I mean, I'm not surprised that they denied it. Um, I didn't think it was particularly well written. It's very conclusory and not convincing, but hey, what's up? They got the parties wrong in the conclusion. They spelled town wrong in the caption. They don't have Lamborghinis. Yeah, um, I wasn't impressed by this. Yeah, there are two cats. There's Oasis Cat and Cat Not Williams. I don't know, that's fine. This should have been half as long as it was. Like, they're recognizing that they're engaging in a specific form of speech. Yeah, I don't know. Ugh, I'm probably gonna wrap up soon. That's exhausting. Anybody have any topics you want to hit before we wrap up? Ooh, that sounds good. Is that like you have to do like the laminate, right? With croissants, you have to do like the butter folding. What's that called? I can't remember. But yeah, that takes forever. I'm impressed. Yeah, this motion, not this one. This one's complicated. And this one. This one did not need to be this complicated. What made me decide to go to law school? I always wanted to, from like middle school. I just thought it would be a good fit. I like reading. I like arguing. I like being right more than anything. Um, but after I got out of undergrad, I didn't want to go right away, and I kind of like misspent most of my 20s. I was a bartender for a while, and as I got towards the end of my 20s, I was more tired than I was before. Yeah, the money is always helpful, but yeah, it was just finally time, and I'd wanted to for a long time. It was more a matter of putting it off than coming to a decision to go in the first place. But yeah, I always had a suspicion that I wanted to. When I was in middle school, we had like a career test thing, and I said lawyer, and I got like lawyer as a result back then. It just took me a while to get there. I didn't go to law school until I was 31, so it's fairly recent. Those kids that go straight through are terrible, all of them. But yeah, I'm glad that I did. It's interesting. You learn so much. There are so many different areas that you can branch into, and the law touches everything. And I like it. It's it's been it can be frustrating. It's time consuming, and there's no instant gratification. But um, you know, I like figuring stuff out. Yeah, thanks. I don't really regret the misspent 20s. I think I probably learned more about being a lawyer and actual lawyering from being a bartender than law school. Like, if you can convince a drunk person to, like, leave you alone, that's 80% of what you need. I ever think I'd be on YouTube? No. No, not at all. I didn't even think I was going to tweet. Um, I didn't even tweet until the Moontooth thing started. The kid in line who also wanted to be a lawyer. Which one was that? But yeah, no, I didn't think I'd be on YouTube. This wasn't planned. But yeah, people started asking me to come on shows, and I quit my job because I had to practice in Georgia and I couldn't. So I had some free time. Yeah. Yeah. I gave up on some dreams, but I eventually picked one. What's the story about the kid in line who also wanted to be? Oh, I know what you're saying. The trolls. Yeah, that was the middle school career thing. We were in line to wait to talk to the guidance counselor, and the kid in front of me said he wanted to be a lawyer, and the guidance counselor, this was like 7th grade, and he said, you don't want to be a lawyer, they're all alcoholics. And then, yeah, that's right. He said they're all alcoholics, and I was like, oh, that's concerning. And then I got to the front of the line, it was my turn. He said, oh yeah, you'll be great, that's a great fit for you. And I still don't know what he meant by that, but I did become a bartender first, so maybe he was onto something. With the MBA that I have now, it would only take a couple of years to get through law school. I don't know. I think it's a flat 3 years in most places. I know some law schools do like joint MBA JD programs. I don't know how that works if you already have the MBA though. Law school should only be 2 years anyway though. It used to be 2 years until like the 20s or 30s, and then they added a 3rd year. There's a judge named, I think it's Learned Hand. Let me double check. I think he did not finish law school because he finished his 2nd year and they told him to go back for a 3rd year and he said no. Let me make sure that's right. I'm not going to be able to find this. But yeah, for the longest time it was 2 years. And law school shouldn't be any more than 2 years. The 3rd year is pretty much just a waste of time. I think 3 semesters for the school and then 1 semester for bar prep. He saw that I had the brains to be a lawyer. Maybe. You should be able to test out of it. Yeah, I mean, I think everyone should be able to do 2 years. I got my best grades for my 3rd year when I stopped caring about my classes. Once you realize that it's just how exams work and how to play the game. It's a lot easier. And yeah, I like tweeting. That kind of grew. It kind of exploded with the Karen Reed stuff when I started yelling back at the other people in the Karen Reed case, the crazy people. But that was fun. That's where I started getting the invitations to go on shows. And hey, Martha, tell me more. I'm curious to hear. I think I'm missing some context. All right. Got pissed through my own videos. Yeah, the videos are hard. I think the streams are easier because you can't restart. I am a grifter. I've spent thousands and thousands and thousands of dollars on pro bono cases and sharing files, and then I have like one YouTube channel and doing one show, and people are calling me a grift. Oh god, that reminds me. I need to do that video about the thing that was so funny this morning. What was it? The RICO. There was a RICO accusation on Twitter this morning. Where is that? That was so funny. Where are you? Oh, where was it? Oh, here we are. Somebody from Twisted Tragedies? Or Sunny Spirit from the. Oh man, they accused the content creators of being of having RICO conspiracy. That'll be fun. I don't do Twitter. Yeah, I didn't either until I guess 6 months ago now. Oh man, hold on. I can just post this. Uh, yeah, it's 40 seconds of genius. Hold on, let's see if I can do this. She's disgusting. Lives in a motel in Massachusetts. The Twisted Tragedies one or the Sunny Spirit one, or both? I gotta share this on. Uh,
these people that are hired guns, like oh, the RICO stuff, just oh, the RICO stuff, just real quick. What I think is happening is that they have these people that are hired guns, like Olivia or whatever, her PR,
Yep.
that sit and do that shit all day. And I think that they have all these fake accounts, and the money that they're raising, they're funneling back to the creators. This is how I think that they're paying the creators, so that there's no actual paper trail. They're paying
Yep.
the creators with the money, have all these fake accounts, and the money that they're raising, they're funneling back to the creators. This is how I think that they're paying the creators, so that there's no actual paper trail. They're paying
Yep.
the creators with the money that they're raising from their supporters, and then they're taking money out of that Venmo or that whatever
She's
kind
got
of fund,
Venmo, CashApp, and PayPal. Yeah.
the defense fund, supposedly. Oh, the RICO stuff, just real quick. What I think is happening. Oh, the RICO stuff, just real quick. What I think is happening is that they have these people that are hired guns, like
Okay, let me try this one other thing. I can just add something here that should work. Capture. Still can't? You can hear now? Okay. Okay. Let's see. Hint. Man, I'm trying to get this to work. Now sing? No, I'm trying to do a paint thing about these RICO cases. This is frustrating. Let's do this one. This is the, come on. Can you hear me now? Is this better? I wonder why it's usurping your audio. Okay. Oh. Okay, can you hear me now? Can I see myself on YouTube? All right. Okay. Finally, we can get to the important business. Okay, so for starters, they have these people. Okay. Like Olivia. So Olivia goes in here too. But smaller font, probably. That's just an example. Okay. What's next? They have fake accounts. So probably, I'm guessing they is probably here. Okay. I guess fake accounts aren't people though, so it should be a different thing. It should be like this. Fake accounts. What's next? The money they're raising funnels back to the creators. Okay, so I need another shape. Let's do this. We'll do it in green for money. Okay. The money they're raising they filter back to the creators. No. This way. This is the way. So, I don't like this one very much. We're going to redo this. Okay, here we go. There we go. That's better. That's more accurate. Then the money goes back to the creators. I majored in economics, actually, which is kind of funny timing to be asking that. English is actually a really good major for law school, though. Okay. The money they're raising funneled back to creators, taking money out of Venmo. Okay, I need to listen to this again. Can you... Okay, so this should be a funnel, actually. So let's make a little funnel here too. They're funneling the money back. I guess these are also creators, though, because these people are the creators. But people are in red. All right, what do we have left? Okay, this is where it gets genius. And by genius, I mean, So then there's people over here. We'll put them in blue. Let's make it smaller. Donors. Okay. So we have, let's just bear with me here. The donors, that still doesn't work, actually. How can I do this? There's a point to this, I promise. Donors, do another green. Venmo. PayPal. Okay. So this, what's another color that we can do? Let's do yellow. The last thing they say, the reason they do this is so there's no paper trail. Of course. So there's the money from the donors to PayPal. Then the money from PayPal is withdrawn into the fund. Then it's withdrawn from the fund to go to they. And then there's another remittance that goes from them to the creators. I don't know what any of this is. I don't know what the fake accounts are. I guess maybe the fake accounts are also giving the money to the donor, but I don't know where their money would come from. So that doesn't make sense. We're getting rid of that. That's insane. Okay. So let me do this real quick. Yellow. No. What are you doing? Oh, right. There's a little key here. Yellow. No. That was annoying. No paper trail. Okay, so there's one last step. Let's see here. Let's see. Massachusetts law. So Massachusetts doesn't have a RICO law. Let's see. I'm not seeing it. I'm starting to think that she might not know what she's talking about. See, it seems like what they're describing is marketing. Like, they pay people to market their cause to raise money, and then they pay the marketers and keep the rest for their defense fund. I just don't know. But then who's getting the rest of the money? Is Karen splitting it with the lawyers? I think I've taken this as far as I can go. Fed rule. Fed not apply then. The federal RICO stuff. Yeah, I don't think I can get into that. I can't believe there are 42 people watching me do whatever this nonsense is. Is this for the Karen Reed case? I mean, tangentially, it is kind of for the Karen Reed case. Hey, YSL Kels. I'm sorry that I just became just an unhinged, psychotic person the second you logged in to watch my stream. I'm not, I haven't spent a lot of time looking at RICO, though, so they probably know more than I do. Oh, my God. The IRS knows who each of those people are. Yep. I don't even know if I'm a fan of this right now. I'm definitely saving this, though. Oh, my goodness. Let's see what other dumb stuff I have. Okay, this is probably the last thing I'm going to show because it's funny. Okay. Oh, my goodness. My OBS is so messed up right now. This is a Kenneth Copeland, aka Lil Rudy, case from apparently 2020. I don't know nothing about it. This is the same motion for gang-related evidence you'll see in every case. And they didn't finish the introduction. They just left the template in. I haven't really had an opportunity to share that yet. My favorite part is that they actually left the footnotes in as well. Nope. Consider inserting police reports, statements, proffers, and or secondary sources. But to me, it's the footnotes that are just really what tie the whole thing together. It's just so long. All right, I'm rambling now. I gotta go. I've completely lost my voice. I missed a letter in the what did I do? Oh, come on. There we go. Oh, no, I've got my favorite part. They call this part, optional section considering inserting police reports, the admittedly non-comprehensive overview. That's technically correct. Yeah, that was fun. That was much longer than I intended to go, and didn't cover. Oh my God, I can barely talk. How long have I been going? 2 hours. Oh, you're right. I'm at like 2 hours and 51. All right, what nonsense can I talk about for 8 minutes? This is a case that I've been holding on to for a very long time that I haven't talked about yet. It involves some of our favorite people. Here we go. So this is a case from, there's a 2002 murder. It didn't get trial. I'm not even showing the right thing right now. Here we go. This was a 2002 murder. I've written like one or two things about it. In this case, there was a gun that was the only thing that tied the defendants to the murder, but it wasn't the murder weapon. I don't think I can read the whole thing right now. But this is opening statements. What you need to know is that this is the gun that tied the defendants to the murder scene. And the victim was never shot with a .40 caliber. So keep that in mind when you go over the following. Evidence will show that these three guys shot him to death with an AK-47 and a .40 caliber handgun inside his own home. Nobody in the state, prosecutor, police, believe that he was actually shot with a .40 caliber handgun. But the prosecutor, I'm not sure who she is gonna tie the handgun to the murder repeatedly throughout opening statements. Got out of the blue Cadillac with assault rifles and handguns. They approached his home with handguns. They beat him with a pool stick, shot him with an AK-47 and a .40 caliber handgun. Let's see. Evidence will show they were brazen enough. Blah, blah, blah. We get to witness number one, Meredith Cooper. She's going to come in here. She was sitting in an abandoned house, actually standing there. She was actually smoking crack. She was straight up with the police. She was smoking crack. But she knew them too, and she saw them go past. So, you got some crack, and you get a gun. That wasn't the gun. Walter White. Heisenberg knows them. He was standing there. He was at Mr. Scott's house, which sits right next to the abandoned house Meredith Cooper was in. Oh, man. I don't know about that one. YP. Evidence will show at the time Eric Kemp was ambushed, while they were in the back doing things they didn't have any business doing, they were cooking crack. These are the cousins, Bojack. Evidence will show the police did their job. They collected evidence. They dusted for fingerprints. They checked the area for blood and DNA and things of that nature. You know what they found? They found the DNA of the cousins. They talked to Meredith Cooper, the crackhead. They talked to Anthony Stiles. Here of these statements witnesses gave to put these three defendants in Eric's place at the time. Ask why are we here in 2013? The murder was in 2002. Evidence showed that 2 other suspects that were seen out there that night were found dead within 48 hours of Kemp's murder. And the lead investigator was transferred, but he cleared the case. So the case was cleared because the people who were the suspects were killed in a retaliatory killing the next day. That's true, Sarah. Why are we here now? Because the arm of the law is long. The evidence will show their actions caught up with them 10 years later when their former associate, Daniel Chapman, happened to be in federal custody on his own probation violation. Daniel Chapman was up to get sentenced and had a minimum recommendation he was looking at. So Daniel Chapman looked out for Daniel Chapman. He knew within the federal system, when you make proffers, you better not give them any BS, because once they found out that you're lying, rejection of proper statements, opening out arguments, also bolstering, overruled. Daniel Chapman told them everything, and one of them was the murder of Eric Kemp, who used to hang with Fathead and JJ. There's 2 of the 3 guys. So Detective A.C. Smith, he just happened to be there. He starts going back and reworking the case. This is my favorite part. What does A.C. Smith find? He got not just the proverbial smoking gun, he got the literal one. Again, not the murder weapon. There's a car. Now we have James Brown. So we have James Brown and Walter White and Bojack. All 3 of them were riding around the car that happened to get stopped. Lloyd was in the back passenger seat. James Brown and J.J. McDowell were in the front. James Brown had a warrant. He jetted. He ran. These 2 defendants, they didn't run. When the police searched the car, underneath the driver's side seat near the rear floorboard, the rear of the car where Lloyd Stevens was sitting on the passenger side, they found a .40 caliber handgun and several grams of cocaine. So A.C. Smith was under the driver's seat, but it's the passenger back seat person it belongs to, apparently. 10 years later, takes this .40 cal, goes and has it tested compared to that .40 caliber shell casing that was found at the murder scene, but not the murder weapon, and it's a match. Nobody in the car knew where the gun came from, knew where the cocaine was. As time would have it, or things would have it, the GBI does its testing. They matched the serial numbers. This is where it gets good. I don't know, Moon Goddess. It's somebody named Love, but I'm not, The weapon, I'm going to tell you now, it got converted to property last year with the Atlanta Police Department, and it got destroyed. But the record of the test and the comparison, it remains intact. So the 10-year-old gun that isn't the murder weapon, that she spent the whole time calling the murder weapon, was tested and then destroyed before the trial. So you can't actually check to see if the gun's a match. And they have crackhead corroboration. You'll hear from these witnesses, not a single one of them will be without some criminal history. Evidence will show that each one of them, they told the police in 2002 what they saw. Oh, yeah, this is another. This is how I found this case. It's a 131 case, because of course it is. Listen to what the witnesses say. They're standing in different places. They're seeing what they see. Their statements aren't going to be lock, stock, and barrel, as you would expect if they got together and told each other what to say. They're all standing in different places when they saw what they saw. Judge the reasons that they have, as the court instructed you, for saying the things that they say. Oh my goodness. All right, we get a look at the jury instructions. Hey, Kelly. Yeah, I've got to make it to 3 hours. I think I'm almost there. Oh man, I just made it. I got to do this one last thing now. This is insane. I got to find this. Where is it? This is the last thing I'm going to do. Oh, where is this part? Hey, Kel, thank you. And Kel, yeah, it's always 131. Oh, there's just one last part I wanted to find. Not the Dennis Shy part, which is my favorite part. Maybe we'll just end with that, though. I'm sure this is great viewing. This is irritating. All right, we're just going to do a Dennis Scheib special instead. Dennis Scheib's a lawyer. He's done more trials than anybody in Georgia that alive, I have to imagine. He's shows up to the hearing, says, "Sorry, I'm a little late. I live in Morgan County, and I was learning how to shoe horses." He just walks. He goes straight into the motion, and he's had a blood feud with Ms. Love for decades. Let's see. I found that this regime we have here, the district attorneys, they don't do that. They leave part of it out. I'm going to present State's Exhibit 1. Dennis Scheib comes back. You can just say yes or no and we can be done with this. Your Honor, he's properly served the subpoena. Dennis Scheib. Well, they could have done something with this if they wanted him to testify, Judge. It's still my position that unless they give him transactional immunity, I don't believe that. See, it says on here he will testify truthfully. That's fine, but didn't say in here he'll be testifying in a murder case. That's a big difference. Man, I can't find what I'm looking for. We're getting the good part. Where is it? Okay. He's just getting ganged up on. And his client's about to call as a witness. He doesn't want him to. Scheib says, just to let the court know, in the transcript, said he would testify, but he didn't sign up for murder case number 1 and number 2. I have not ordered my client against the court's orders. As defense lawyer, the state may or may not know. I can advise him what to do. I can't give him orders. Only the court can give him orders. So my advice will be one thing, but what you order is something else. I'm not a judge yet, nor do I want to be. Thank you. Perfect. Hey, Kelly. Yeah, we need to do a show soon. I know. Probably next week. Week after or something like that. Whew. I need to go. I'm so tired. I can't believe people are still listening to this. This case is, I've been holding on to this case for so long. It's like a multi-thousand page transcript. but I definitely want to cover it at some point. But yeah, I'm gonna call it a day. I'm exhausted, and thank you all for coming. And I'll do more of these. I didn't expect to have this much interest, but yeah, I'm wiped out. I gotta take a nap now. I gotta take the dog out. But yeah, if any of you had any ideas, it's 1 in the middle of the night. I've been writing all night. But yeah, if anybody has any requests for topics, definitely let me know, because I don't know what people want to hear clearly. But yeah, thanks everybody.